I kept hearing Amy Odom earlier talk about the VA people that were here. VA people. But I love this collaboration, and I think Professor Drake did that on purpose to show that we are all on the same team. That's an important message that I think is lost a lot of times, that even us at the Department of Veterans Affairs, we know we all work together. We're all here to help veterans. We're all trying to do what we can to assist our veterans. Happy Veterans Day on that note. But I think she did this on purpose too. She has the lawyer and she has the VA, and y'all can listen to us speak for a while.
And we get along pretty well.
Yes, we do.
All right, so we're going to go over the TBI and PTSD claims and development, both through the appeals process and developing the evidence that you need. There's a lot to get through, so we're going to try and get through everything within the hour and then take some questions at the end. But if you do have some, I'd ask that you wait till the end, just for the fact that there's a lot to get through in this hour that we have. So when we're going through this, we're going to try and get everyone in here to at least understand some of the attributes associated with a TBI and PTSD claim, understand what kind of evidence you should be developing, because it's going to vary depending on what you're looking for, what kind of secondary conditions, that kind of thing. Recognize what you're looking for in a C&P examination, so you know what you're looking for to develop your own evidence if you need a medical opinion or something along those lines. And Amelia's going to be explaining a lot more on how the ratings are done, because she understands that far better than I do. So, and you're going to have to excuse if the clicker doesn't work. I've seen professors have trouble with that quite a few times. So first thing we're going to discuss is the duty to assist and the how to develop the claim from the regional office perspective. And Amelia's going to kind of cover that, what we're looking for in the DBQs, and there's specific qualifications that you need for an expert whenever it comes to a TBI claim. So Amelia, you want to kind of take that?
Sure. And I know a lot of this has been covered throughout the day today. So we will fast forward and apologize for any redundancies. But the way we provide our duty to assist changed when we started sending out the EZ forms, when we started accepting the EZ forms. So where it used to be veterans would receive letter after letter after letter notifying them what they could provide in support of their claim, now the intent is to do it all up front. So when the veterans submit a claim on a 526EZ or a family member on a 527EZ, the EZ form simplified this and notified veterans and claimants up front what they can submit in support of their claim. So the duty to assist simplified a little bit and reduced processing times, because now we don't have to continue sending letter after letter out. We do it all up front. The disability benefits questionnaire, we discussed those earlier. I think it was Amy Odom that described how examiners are given a template, what exactly we're looking for when we evaluate claims, and they check boxes on a template, fill in numbers for something like range of motion. Those are the disability benefits questionnaire. It lays everything out, what exactly we're looking for, and it gives the examiners some clarity what they need to provide us to help substantiate these claims. Some disability benefits questionnaires require experts in the field, specialists for TBI claims, psychiatrists, psychologists. I'm sorry, that's PTSD claims.
Something along the lines of like the neuropsych and that kind of thing.
Yes, yes. And that developing additional evidence bullet leads back to what I first discussed with the duty to assist, where we are required by law to notify veterans and claimants what they can and what they need to submit to substantiate their claim. And that includes developing additional evidence. If it's federal records, if it's records from a private source, we go after that. The VA has a duty to assist and obtain that evidence and obtain that information that helps substantiate these claims.
And that kind of leads into getting those DBQs too, as discussed earlier, with the may be associated with. It's a very low standard to have before you get those DBQs, but that's about the beginning of the veteran's development of their claim. And Amelia, didn't you mention when we were talking yesterday about the fact that the first DBQ actually needs to be completed by one of your examiners?
Yes, in some of these cases, and that was something else that Amy Odom had mentioned earlier, in some of these cases, when you are submitting evidence to us, say an initial PTSD claim, a TBI claim, hearing loss is another. The VA has some of these disability benefits questionnaires that we are required to go to a VA examiner for. So while you may submit them from a non-VA examiner, and we will consider that evidence, we consider everything that's submitted to us, sometimes we still have to go out and obtain an additional disability benefits questionnaire from a VA doctor specifically. So say, for instance, you're representing a veteran and you submit a disability benefits questionnaire for an initial PTSD examination. That veteran went to his or her private psychiatrist, submitted a disability benefits questionnaire to us. We will look at it, we will consider that evidence, but we are still required to go out to our own VA doctor for that initial PTSD.
And now once that's taken care of, they're going to turn around and give us the initial rating decision. And I kind of discussed more here about dealing with PTSD than the TBI. We'll get into that more later in the discussion. But as far as whenever you get that decision, you're looking at what's granted, what's denied, and why. That's the big one. Now, at times you'll see a need for a corroborated stressor or something like that. In the case of a combat vet, their lay testimony alone is enough to establish that stressor if they were shown to be in the circumstances, conditions, or hardship that's associated with that kind of service. Now, in the case that they were overseas or they had a stressor, but they weren't a combat vet, 3.304 F3 deals with fear of hostile military activity or terrorist activity. Now, that is where a provider can actually verify that that stressor is sufficient to substantiate that claim for PTSD, but in that particular case, you need a provider that's been approved by the VA to provide their CMP exams. So you're looking for QTC or LHI certification. I think that's all I got on that one. And that's kind of slides right into getting our independent medical opinions. Now, in the PTSD and TBI world, we're looking at not only the current diagnoses, but also clarifying if there's a wrong diagnosis. We're going to hope they'll explain the impact that the service event had on the veteran, discuss exacerbating factors. We had a case recently that comes to mind where the vet came back and he had PTSD, but was never diagnosed and never received treatment, and his PTSD just got worse because he kept dealing with those stressors, dealing with those issues, and not having the kind of treatment that he needed. It kind of goes back to the gaps in the record that were discussed earlier with the FIDO and just suck it up and move on. And let's see, we got the provider. So other evidence, specifically the gaps, we've got issues with years between treatment, or between getting out of service and treatment. And that can be caused by any number of things. I went the wrong way on that one.
It's the PowerPoint gremlins.
Yeah. It's this little remote. I'm not used to it. Veteran trying to deal with his disability or her disability on his own before they finally get overwhelmed and search for help. Going to a private provider. If they're talking to a psychiatrist or psychologist, but not with the VA isn't going to have those records initially. No treatment for any number of reasons. But so how do we go about filling these gaps? Now, this was discussed earlier too, so like Amelia said, I apologize for some of the overlap, but we're looking at buddy statements and statements of the veteran themselves. So they can cover a number of things, the issues with day-to-day living, habits and routines, changes they've noticed before and after the veteran service. If you're looking for service connection, that's always helpful to have. How has it affected his relationship with his friends and family? Did they notice that change after service? Co-workers, if you've got a veteran that's having trouble at work, can talk about special accommodations, problems with authority or leadership, and just problems following directions and instructions normally. Now, when you get a service member, their buddy statement, they can talk about what happened in service. That's going to help substantiate the TBI, the impact, or whatever that stressful event was.
I'm going to weigh in on that one, Nick. The fellow service member buddy statement oftentimes is helpful because although the evidence we need to corroborate something may not be in your veteran's file, may not be in your veteran's official records, it might be in the buddy's. So a buddy writes in and says, I was at this location at this time and place. Your veteran may not have the information to corroborate. Why can't I say that today?
It's a hard one to get out
I say
sometimes.
that every day. To prove that, I'm just going to use proof. But the buddy, we can substantiate it using the buddy. We put them in the same units, and there's our evidence. There's the evidence we need. So these buddy statements are from service members specifically, are very helpful when trying to prove these cases.
Okay, thank you. Now, other helpful evidence, we're talking statements from the veteran themselves, and that can go to the initial severity regarding that traumatic brain injury. They can talk about what happened, were they hit by an IED, did the Humvee flip. You can have statements of witnesses to the injury, and also the history provided immediately after the fact is some of the most persuasive evidence to talk about exactly what went on and how bad the injury was. And service treatment records right after that initial shock. Now, we're getting into Amelia's wheelhouse right now, so after filing the NOD to the original appeal, it's going to go before the DRO, and she's going to start developing more evidence, what she thinks she needs for the decision, but as we're developing on our side. And she's going to issue her statement of the case, and that's going to talk about why she granted or denied benefits and every regulation associated with that, so that the veteran knows what they need to appeal that decision if they want to continue. And did you want to get into any more on that, or?
Yeah, I think so. Amy, I keep quoting Amy Odom because she's fantastic. Amy Odom said something earlier about the VA being the guardians of the taxpayer's checkbook, something along those lines. And I like to give away the farm. I'll be honest with you, because the law allows me to. When it's within the regulations and when it's within the law, I and a lot of other decision makers in my office, we do everything possible to grant everything we possibly can. So again, this goes back to not every VA employee is nasty and evil and mean. I grant everything I possibly can and do all the development I possibly can. If I think there's a shred of evidence somewhere out there lingering that I can go after to grant this benefit, I do, as do a lot of my coworkers. That said, sometimes we can't grant. And when the issue is on appeal, so the rating decision has been completed, an appeal has been filed, and when the issue is on appeal, a notice of disagreement has been filed, it comes to us, it comes to the decision review officers to take another look at it. And at that point, we review everything, go after additional evidence if we think it would be helpful or is required by law. And then only if we cannot grant it do we issue the statement of the case. So if we have to continue to deny the benefit that's claimed, that's when the statement of the case is issued. It's 20 some odd pages long because we have to include all the regulations that are pertinent. Usually if you flip to the last few pages, you'll have the actual decision, the narrative of why we were unable to grant this benefit. Sometimes we can grant completely. Sometimes we can grant partially. And in that case, we will do this rating decision. And the rating decision is usually a grant of some benefits in some way, shape, or form. And the statement of the case is what goes along with it if we weren't able to grant everything.
And in that case, I've seen the SOC come out that says we can't grant over this, but the RD is issued at the same time.
Right.
And Amelia bringing up how she tries to give away the house and everything, the farm.
When legally allowed.
Yeah, but it brings up a good point that I should have included in my PowerPoint, and I meant to, and that's talking with the DRO during an informal conference, and we wanted to discuss that just a little bit. And now that's whenever you've got your appeal pending before the DRO, and you withdraw the hearing, and you can have a informal conference, sit down, talk. And I've requested at times 30 days extension when there's something missing from the record that you need to make that decision, so that we can submit it and leave the record open to get that extra evidence in. And that provides a very useful opportunity to try and save your veteran from that additional appeal and waiting another couple years to get to the BVA level.
I like sitting down and talking to the advocates, whether it's a service organization or an attorney or a non-attorney practitioner. I enjoy those conferences because a lot of times there's a great information exchange, and we can walk away and it puts different ideas. Oh, I didn't think about that regulation. I didn't think about it that way. Let me see what I could do with this. One more thing on this slide. If you are representing a veteran and you do have something on appeal and a statement of the case comes and it doesn't look like it makes much sense because it says entitlement greater than 70% for PTSD cannot be granted. And you look through the file and you think, well, wait a minute, this veteran right now is only 10% for PTSD. A lot of times the rating decision lags because it has additional authorization and promulgation, and there are a whole lot more government hoops that you have to jump through before this rating decision gets to you. So while I'm doing both decisions on the same date, the statement of the case with all the stuff I can't grant and the rating decision with the stuff I can, although I'm doing them on the same date, you may get the statement of the case within a week, and the rating decision doesn't come for 6. So a lot of times there's not much I can do with this, but a lot of times there'll be a rating decision that grants a veteran 100% overall. I'm sending this rating decision telling this veteran he or she is going to receive a substantial retroactive payment and is going to be 100% permanent in total, but on the same day, unfortunately, I have to send the statement of the case. It denies a lot of stuff. The bad stuff usually gets there first. So I think my point is sometimes that rating decision is explained in that statement of the case, and the rating decision is the positive, is the good stuff. Go ahead, Nick.
Okay. I think we've actually covered all of this already. It covers all the statutes and regulations, so we're going to go ahead and work past this slide. Appealing the SOC. So whenever you get the denial, you're going to be looking to try and get those benefits for the veteran. And if we can't work something out, sometimes you have to go up to the Board of Veterans Appeals. Now that's done via the VA Form 9. We don't actually submit argument with this or anything. It's just a form that the VA provides. There's a fillable PDF on their website. And we include language along the lines of the veteran desires to appeal all issues listed within the statement of the case, all issues that are raised by the record, including failure to adjudicate issues and claims reasonably raised. Now, we'll get into some more of that here in the next few slides, but that's kind of covering all your bases because there are secondary conditions that once that first one's granted that can get be going up with it. There's TDIU, there's a number of different things that can all be affected that aren't actually discussed in that statement of the case. So now we're getting more into the TBI itself and the diagnostic codes for it. TBIs are rated under 4.124A for neurological conditions and convulsive disorders. Now it describes three different types of impairments, main areas that we'll get into coming up: cognitive, emotional, behavioral, and physical. Now all of these are rated separately. They're rated under different diagnostic codes, and can honestly add up to quite a good rating for the veterans whenever they're done properly.
And this is what is included in your handout. Mm-hmm. One of the handouts you received, or it's at the back, it gives you what diagnostic code 8045 is. And what we're looking at, maybe on page 2, I'm not exactly sure what
Yeah, it's page 2.
Is it page 2?
And
Okay, it starts on page 2.
extends.
And it's lengthy.
Quite a few pages in there. The first page is actually for the mental conditions in particular. That's going to be your diagnostic code, or the rating criteria for PTSD. So we're getting into what's it mean for our veterans claim, what kind of records are we looking at, what are they needing. Do you want to talk about the development on your side, and I'll talk about what we're doing at the same time?
Sure. Yeah. No,
Oh,
well,
yeah.
Requesting records and looking for problems relating to each of these areas, that's what we mentioned earlier with the duty to assist. Part of that duty to assist is to obtain VA medical center records. So one of the first things I do is pull up, because we have the partnership with the VA medical centers, one of the first things I'll do is pull up the medical center records and look through those. I upload all of those because BVA likes them, and they're good evidence. So we're requesting records and looking for issues that could be a diagnosed TBI or symptoms of a TBI if there is no diagnosis yet. And sometimes veterans will ask us to go after private records as well. And so that too, we have to develop for those private records that a veteran or a claimant asks us to go after.
And while she's doing that, or usually after they've gone through all of that, we're looking at the CMP exams. We're going through those medical records ourselves, doing a very detailed index of whatever disability we're working on at the time. If it's PTSD, we're going through the psychiatrist and psychologist records, looking at the social worker that the vet's been working with, just looking for those things that are on the first page here for the different ratings for PTSD. We're going to probably end up requesting a medical opinion from one of our outside examiners, and they'll write up a report. And with the standard within the VA, that's likely as not, it helps Amelia to grant based on the benefit of the doubt, if nothing else.
Yes, it does.
Go ahead. So we're going to be developing that. We're going to be talking with our experts. We're going to be talking with the vet while getting their statements, getting the buddy statements, anything that we can do to support that claim, and put as much evidence on Amelia's desk as possible so that she has the best possible chance of granting the benefits to the veteran.
There's nothing I like more than a claim coming across my desk with rock solid evidence, even kind of so-so evidence, but it's there. An attorney or a service organization or even someone that's not represented, bringing in something that I could look at and say, oh, this is a grant. This is a grant all day. This is there. I don't have to go after anything else. We will gladly do so, but handing VA that evidence on that platter, I think somebody brought this up earlier about developing these cases. I tell people, lay it all out for VA. Lay it out. These are the facts. These are the regulations. Here's the evidence. We're giving it to you. You're welcome. And that helps us do our job. That helps us grant these benefits and these claims.
We've already gone over this. The three main areas that are defined in the regulation is dysfunction arising from TBI or cognitive impairments, emotional, behavioral, and physical. Cognitive impairments, as defined by the Diagnostic Code, is decreased memory, concentration, attention, executive functions of the brain, such as goal setting, information processing, planning, organizing, prioritizing, self-monitoring, problem-solving, judgment, decision-making, spontaneity, flexibility, and changing actions. There's quite the list. But this gives you an idea of all the different things that you can be looking for in these records and how you're going to be pulling those out to develop the claim better, or to better develop that claim, to give the veteran the best possible outcome in his case. The emotional behavioral are defined under 4.130, which is the front page of the handout that we gave you, and this provides all of the diagnostic or the rating criteria for a PTSD or a mental diagnosis in general. I believe I have a slide in here discussing a recent case, and nope. Okay, there was a recent case that came out called Bankhead that discusses this kind of criteria and how to get the most out of the rating for a veteran. In particular, we use it for going for that 70% rating you see there on the page, because Bankhead essentially says if there's not an analogous symptom at a lower rating level, then that rating should be at that higher level. In particular, with the 70% rating, you'll see in there that there's suicidal ideations. It doesn't define whether it's passive or active, so the vet can have a note in that record when you're going through those records, and it's easily missed, saying, well, yeah, I've thought about how it would be without me, what people would do, would anybody be upset? Or you have, I've got a gun, I'm thinking about going home and using it. That right there gets you that 70% rating, which makes getting up to that 100% rating, whether it be Schedule A or through TDIU, much easier. Now, subjective symptoms, Amelia can actually describe these a lot better for you and how she deals with these. But they have, it's rated under evaluation of cognitive impairments and other residuals of TBI not otherwise classified. So it's going to be the headaches, the shakes, the tremors. Amelia, do you want to talk about how you look at those? We were talking about that last night.
So the reason why this is all lumped together in our presentation today, the post-traumatic stress disorder, or some people now call it post-traumatic stress, the PTSD and the TBI, the traumatic brain injuries, because so often they can't be separated. So often the same incident caused both. So often the symptoms overlap. And we'll see claims for both at the same time. The subjective symptoms, and now what we've been going through with the cognitive and the subjective, and we're going to get into the emotional behavioral, which we just did, these are all falling under the TBI. So imagine you have your umbrella and you have your traumatic brain injury, and this that we've been discussing with the subjective and the emotional, that's all falling underneath the traumatic brain injury. That's what starts on page 2 of the handout we gave you, is what the VA is looking for and what doctors are looking for when we're evaluating the traumatic brain injury. The traumatic brain injury gets down into these subjective symptoms and kind of makes a right turn. When we start talking about physicals, when we start talking about headaches, Meniere's disease, the ringing in the ears, when we start to talk about physical symptoms and physical manifestations of the traumatic brain injury that might also have been caused by the incident. So a blast can cause TBI, a blast can cause hearing loss. At the same time, we are looking at those as the subjective symptoms. So VA, what we try and have our examiners do, and if they don't, we have to kick it back to them, is to have them separate out the subjective symptoms that can be independent. So there may be ringing in the ears, and I can pull that out of this and evaluate it separately as a 10%. There may be migraines, and I can pull that out of this and independently evaluate that. Migraines up to
Prostrating.
50,
It's up to 50, I believe.
50 I think it might, maybe up to higher. Anywhere from a 0 to the maximum allowed for these disabilities.
Versus keeping it specifically under the TBI.
Right. So what we have to look at, and what you all as advocates should be watching for, is one, does the evidence allow us to pull out some of these subjective symptoms? Can the TBI, can the hearing loss be separately evaluated? Can the ringing in the ears be separately evaluated? Can the headaches be separately evaluated? And if so, is it more or less advantageous to leave it in here? And let me tell you why. The subjective symptoms, if you turn to page...
I believe it's the last one.
1, 2, 3, page 4 in your handout. Thank you. you'll see the subjective symptoms, what the doctors are looking at. You see there's a 0, and it says subjective symptoms that do not interfere with work. And then there's a 1, and it says 3 or more subjective symptoms that mildly interfere with work. And then there's a 2, and it says 3 or more subjective symptoms that moderately interfere with work. That number is important. See that 3 or more? Because, back it up one more,
Yes,
back it up once, please.
Uh-huh.
Because if I have a doctor using the 3 or more subjective symptoms to give a compensable evaluation for the TBI, and then I have some extras that I can pull out, I'm pulling them out. So say the doctor tells me that we have subjective symptoms of migraines, which would be at a 0, because I have evidence that shows me that. Ringing in the ears, it would be at a 0. And dizziness. So that's my 3 subjective symptoms that I'm using to evaluate the TBI, okay? However, if they give me more than that, if they tell me I have insomnia, the veteran has insomnia, hypersensitivity to sound, hypersensitivity to light, that's my 3 subjective symptoms I need, and I can pull everything else out. I can pull the ringing in the ears out, I can pull the headaches out, and use those to evaluate separately. I tell the rating specialists and the other DROs in my office, when we do training, I'll say you kind of have to run this both ways. Look at these subjective symptoms. Do they give you 3 subjective symptoms that you can use to get this compensable for TBI while still pulling the other stuff out that can be separately evaluated? Is that making sense? I need a whiteboard to write on.
Essentially, if you can get a 40% eval for the TBI and a 10% for tinnitus or something like that versus keeping that as a subjective symptom, you're going to be bumping that rating up for the veteran, which is actually another duty to maximize the benefits.
Absolutely.
So.
Duty to assist. Pay the maximum. So look at that if you're assisting a veteran with TBI. Take a look at that, the subjective symptoms that came back on that TBI evaluation, and see, are there 3 of them in here that I can use, keep the veteran compensable at TBI, but pull the rest out?
That's just. We've actually kind of gone through this already about reviewing your evidence, how the claim is rated. Amelia did a great job explaining that.
Thank you very much, Nick.
You're welcome. And the application of the evidence to the appropriate diagnostic code, that's what I was saying about the, in particular on the mental one, the suicidal ideations. Anytime I'm working on a PTSD claim, I have this first page sitting right next to my desk, or on my desk while I'm going through the medical records, because it just is so helpful to be watching for specific things. And you might see a symptom that you'd think after doing this 100 times over, you'd know the symptoms. Well, you know the symptoms, but you don't know exactly what's going to cause what rating, and it's always handy to have that. And as I said, I've got a copy I keep at my desk at all times.
You're talking about the first page of the handout?
Yes.
Yeah, he's talking about the first page of the handout he gave all of you. And that's the post-traumatic stress disorder, the PTSD coding. So you all have in your handout both the PTSD and the TBI rating schedule, what we look at.
Physical impairments, my PowerPoint kind of got bounced around a little bit, so some of the slides got out of order. That should have been a little bit earlier. But this is going to actually include your motor and sensory dysfunction, visual impairments, tinnitus that we were talking about, seizures, gait, coordination and balance problems, and nerve dysfunctions. There's all sorts of things that actually go into these claims. That's why it's so much to try and fit into an hour, because you can't talk about everything that goes into these. All we can do is give you that general overview and hope that it helps. And obviously, my contact information is in here at the end of the slide, and I've got some business cards that I'd be happy to talk with anybody.
If the doctor tells us we can pull this out and it's not needed for the overall evaluation of the TBI, that's what we're doing. That's what we're doing. To grant at that highest possible level, to give that highest possible percentage.
We've actually covered this already, specifically with the PTSD claims. And go ahead, Amelia.
Go ahead. Sorry to interrupt.
No, it's okay. we've actually handed out the chart, so there's no longer a need to show the chart. But we'll look at this and look at the, as I said earlier, the analogous ratings, trying to get that 70% evaluation in particular. Getting to that 100% specifically for a mental claim is pretty difficult because you need total occupational and social impairment, and that's hard to show if the veteran is functioning, really. And then we're going to try and parse out these ratings because not all TBI has PTSD and not all PTSD is related to TBI, obviously. So
before we get into parsing out the TBI from the PTSD, I want to make a point about PTSD claims. Sean, Lee, and I were talking last night, and I was reminded of an important point with these PTSD claims. Not just when there's TBI related, any PTSD claim that you're looking at. One of the things that is often overlooked, I don't want to say often, but is overlooked sometimes by the VA, is when there's substance abuse or alcohol abuse, some sort of abuse, chemical abuse that is associated with the PTSD. You want that in the decision. You want that in the rating. You want that addressed. A lot of times the doctor will bury it in a narrative somewhere, and they'll say, well, the veteran has alcohol abuse disorder, and it's due to in-service events. The veteran has alcohol abuse disorder, and it's due to PTSD. When that happens, you want that listed in the rating decision. You want that documented because of all of the downstream issues that can come from that. And I will say VA unfortunately misses that sometimes, or if they see it, they fail to actually address it in their decision. My grants look like this. It's post-traumatic stress, service connection for post-traumatic stress disorder with alcohol and substance abuse disorder. Service connection for post-traumatic stress disorder with narcotic use disorder, whatever that is, because again of all the downstreams. Think about if that veteran ends up with cirrhosis of the liver and dies of cirrhosis of the liver. That alcohol abuse disorder is service connected. His or her spouse may be able to get survivor benefits on the other side. Think about if that veteran dies in a car wreck and was intoxicated at the time. The alcohol abuse disorder has been service connected, either on a secondary basis to the PTSD or directly related to service, but usually it's tied in with the mental disorder. So that's a very small nuance that not a lot of people look at, not a lot of people think about, but it makes all of the difference when you're looking at those cases that a veteran overdosed or died by suicide, but there were narcotics involved. So as advocates, please pay attention to that and address that when necessary.
And that kind of goes back to what Amelia was saying a while ago about put it on a platter in front of her. Have your veteran write a statement talking about, I use this to numb the pain, to get rid of these traumatic memories. It bothers me so much that I just drink to forget. Have them talk about that, and then whenever you go and get your medical opinion, have your psychiatrist, psychologist talk about that. Talk about how the veteran uses that as a coping mechanism. Don't have them exclude it. Don't have them try and hide it. You want it, as Amelia said, you want it service-connected. You want it out in front of her so she can service-connect it. And it all just goes into building that case up for her. This gets into kind of parsing them out. As I said, all PTSD cases aren't related to TBI or vice versa, but they can often result from that same traumatic experience, whether it's an IED blast or just an explosion or anything that can cause a TBI is probably a pretty traumatic experience. And so it's important to always have those rating codes right in front of you, the diagnostic codes, so that you can look at them and go through parsing out these issues. As Amelia said, the DBQs sometimes say that the doctor can't parse it out and you can't separate them. So that might lead to a higher rating for that TBI because it becomes a symptom of the TBI. That
happens more often than not, that we're unable to separate both, in which case your decision will be traumatic brain injury with post-traumatic stress disorder or vice versa.
And we've kind of gone through, and I've hammered this a lot, and I will continue to through the presentation, but having that rating or that rating code in front of you is so handy.
Page 1 of your
Yep.
handout.
That's why it's there. Keep in mind that there are different diseases associated with it that we haven't actually discussed already, and there's actually a couple presumptive disabilities after a TBI if they result within a certain amount of time. So we've got some here, Parkinson's, Parkinsonisms resulting unprovoked seizures, dementias, within 15 years of a TBI. Depression, 3 years from a moderate or 12 months from a mild. And we will get into some of what defines moderate and mild and severe here in the next couple slides. Hormone deficiency, do you have pituitary issues after you get hit in the head that hard? All of these things are things you should be looking for in a TBI case because there's just so much to pull out, and there's so many benefits that you can be getting for the veteran that are easily overlooked if you don't keep that diagnostic code and that rating sheet in front of you. Here's some of the ways to figure out the mild, moderate, and severe. We've got loss of consciousness, and this is getting back to the treatment right after the incident. Did they lose consciousness? Was it 30 minutes? Was it 30 minutes to 24 hours? Was it over 24 hours? You're looking at alterations in consciousness. Are they dazed and confused? And you can look through that. These are all going to be, or they should be, in the service medical records.
This is another important part where the buddy statements come into to effect, where we were talking about the buddy statements earlier. A veteran may have documented in their records that they were in a car accident. Well, they were in a car accident. VA has that documented, but there's no evidence of a brain injury in that car accident. Their buddy submits a statement that says, I was there, I was in the car with him or her, and they were unconscious for 5 minutes. That is something an examiner can look at and take into consideration. The veteran in question, the claimant, we can verify the car accident. We can't verify any kind of head trauma. The buddy statement allows us to take it that extra step. The witness that saw that person unconscious for 0 to 5 minutes, here's your loss of consciousness for 0 to 30 minutes.
And actually, when you're looking at claims, one of the things we do during our intake even is one of the questions on our intake form is, did you lose consciousness during service? What caused it? Because we're always thinking about that, and it's important to think about.
I've seen statements from corpsmen. Those a lot of times are very helpful. Combat veterans out in the field, IED blasts, they don't have time to be treated for their brain injury. They want to get right back out there and keep fighting. And so statements from corpsmen are often helpful. I treated the veteran 2 days after the blast, and he or she was showing this type of behavior.
Yeah, the closer you get to that initial incident, the more persuasive it's going to be, and probably the more accurate it's going to be. If you've got a vet that's talking about it 6 years, 7 years down the road versus his statement to the provider a couple days after, it's going to be much more accurate than what you're looking at while you're talking to him and he's trying to get through this appeals process. These are just some of the symptoms associated with the TBIs, and discussing the mild versus moderate and severe. There's a whole nother slide or two with these. It was just too long to fit on here. But looking at headaches, fatigue, sleep disturbances on the physical side, irritability, depression, and anxiety. Do they have mood swings? Cognitive effects, we discussed the decreased concentration and speed of processing. There's all sorts of things that factor into these. Like I said, the moderate to severe is significantly longer. You're looking, we've got physical paralysis, weakness, spasticity. There's appetite changes, decreased bowel or bladder control. There's so many things that go into these, and you can be watching for these. It takes literally days to get through the records. I'm not going to lie to you about that, but whenever
Yes,
you
it
parse
does.
this stuff out, it
Days
helps.
and days.
Again, decreased attention, concentration, memory problems. One of the big ones is short-term memory loss, not being able to retain. I thought I had more to that. But there are so many different issues that you need to be watching for, and this is going to be available for everybody too, right? Okay. And then we're getting into a little bit more of the complicated stuff here with special monthly compensation T, and I don't even completely understand that too well. I've had to look it up recently, and that's about all I can understand from it. So, Amelia, if you want to kind of discuss that a little more.
The government and the Department of Veterans Affairs finally started realizing the extent of the disabilities that were coming back from the current conflicts. Whereas in Vietnam, a lot of these injuries and these explosions and these blasts would have ended with death. They're surviving now, which is, thank God. You know, the veterans are surviving with more modern health care, with better in the field health care. But the government finally realized then that a lot of the veterans are coming back with these additional unseen disabilities, and we need to make sure that they're cared for if they are to an extent where they need aid and attendance. Normally, with aid and attendance, you have to build a ladder. You have to start with a single disability that's 100% service connected. And then you have to build up through the special monthly compensation ranks. We call it alphabet soup, because the special monthly compensation, it's special monthly compensation L, S, M, K, O, P. It's an alphabet soup of benefits. Mm-hmm. And VA finally recognized that these traumatic brain injuries that veterans are coming home with, a lot of them need aid and attendance. A lot of these veterans need someone to help them care for the activities of daily living. But because it's a traumatic brain injury, the alphabet soup and the ladder isn't building properly. So in 2011, they passed this public law which authorized special monthly compensation T, which essentially says, okay, we're going to pay this veteran at the highest possible rate of special monthly compensation, R2. And this is, I'd have to look, $8,000 a month, something approximately that.
It adds up quick.
Yeah. Some of these veterans that are coming back with traumatic brain injury need aid and attendance and are so disabled that they are at the maximum compensable level for VA benefits. They would require hospitalization, nursing home care, institutional care. If they didn't have somebody taking care of them every day, they would have to be institutionalized. Normally, again, we have to build the ladder. You have to do the alphabet soup and work your way all the way up through the highest level of special monthly compensation through the R2. This law lets you jump up about 10 rungs on that ladder, but only for TBI cases. So you can't build the ladder. You're jumping up through the 10 rungs for the TBI cases, and you're giving veterans the R2, the special monthly compensation, which is technically the T, TBI, and it's allowing the caregivers to take care of these veterans at home. It's allowing us to grant these benefits for a veteran who needs to be jumped over those rungs because of a traumatic brain injury.
Now, with the requirement for hospitalization, nursing home care, or anything like that, maybe your veteran doesn't have that level of impairment, but there are other special monthly compensations. As Amelia was saying, it's alphabet soup. There's K, loss of use of creative organ. That's going to be essentially ED, or sexual dysfunction associated with the TBI. Maybe he's got cognitive issues, or he's dealing with emotional issues, and that's another way to look. You've got to be watching for this stuff. There's SMCS. There's
they're housebound.
Yeah.
They can't leave their home.
Mm-hmm. There's just so many of them, and
rungs on the ladder.
yeah, exactly.
Yeah.
You've just got to go through and look for these things and read through the special monthly compensation laws, but they're voluminous.
Terrifying.
And earlier effective date. Now, the law changed in 2008, and Amelia, do you want to kind of explain that side? Because that was before I was doing this stuff. So.
This law here at the top, 3.114, 38 Code of Federal Regulations, 3.114. It's also known as liberalizing legislation, liberalizing law. That's what we refer to it as. It essentially says that you can sometimes give an earlier effective date depending on the facts of the case at the time. And it applies here because the law changed on October 23rd, 2008. And they said at the time, this is considered liberalizing. That's what you're looking for in the statute. It's considered liberalizing. That means 3.114 applies. So for, let's say a diabetes case. I have a diabetes case right now. The diabetes law changed May of 2001. If that veteran had diabetes prior to May of 2001, 3.114 allows me to give him or her a year retroactive effective date prior to the date of claim. So that veteran applied for diabetes in January of 2016. I get the evidence. It shows he or she had diabetes prior to the law change in 2001. I'm giving that veteran a 1-year retroactive effective date. They applied January 2016, I'm taking it back to January 2015 because the diabetes existed prior to the date of the law change. Same goes with TBI, effective October 2008. But for TBI, it's the evaluation that's liberalizing. In the diabetes case, it was the grant of service connection. And this is getting kind of complicated, but y'all are smart, so I know you can handle it. So if you have a veteran, where this comes into play is if you have a veteran that's been service connected for a brain injury or anything similar to a brain injury. I've seen it as post-concussive disorder, post-concussive headaches, brain injury. If they're service connected for any type of brain injury and that service connection has been in effect since prior to that, meaning their grant was in 1971 or their grant was in 1991. There's a chance, because this law was liberalizing, that if they apply for an increase right now, we can apply this greater percentage because in 2008, it allowed us to evaluate at a higher percentage the traumatic brain injury. We can possibly go back a year with the evaluation that we're giving them. So your veteran applies for an increase in their TBI. They apply in November of 2017. They applied yesterday. I look at that case and I see, okay, the date of claim for the increase is November of 2017. They've been service connected for that brain injury since 2007. There's a chance that I can give them that increase going back to November of 2016, 1 year prior to the date of their increased claim, based on this being a liberalizing legislation, the 2008 legislation. So that's something else. It's a little nuanced a lot of times that VA can overlook. We try not to, but it happens. And a lot of service organizations and attorneys and practitioners, they don't know to look for that. If you have veterans that have been service connected for this since before the date of the law change, we need to take another look at that because chances are they're under-evaluated.
And that can actually lead to, okay, we're running out of time. That can lead to
Did we get the 3 or the 2?
We got the 3.
Thank you.
That can lead to a pretty sizable retro payment for your veteran too, which is always helpful for them. And that is something that you need to keep an eye out for. That's something that I need to start watching for actually more closely. I believe that is our last slide.
Look at that. I know.
Talk about timing. So we can. I guess we'll open up the floor to any questions.
I think everybody's tired.
I'm just curious about PTSD and military sexual trauma. After the diagnosis has been rendered, adjudicated claim and set a level of disability, what, if anything, happens after the individual goes through a complete regimen of psychological services and a lot of those symptoms are overcome? Maybe not in totality, but now they can drive down the street and go to Walmart. What, if anything, happens, or do we just, is it remain unchanged forever?
You want me to take it?
If you want to.
Okay. To paraphrase, it's a question about rating reductions. You specifically mentioned military sexual trauma and post-traumatic stress disorder, but in reality, it can apply to any service-connected disability. And what happens if there is improvement? When we initially rate, not initially, anytime we evaluate a disability, the VA makes a determination at that time whether or not we think that there will be improvement. And in some cases, we will put a routine future examination on that disability and on that percentage. In some cases, we don't. If the veteran's over 55 years old, if that disability has been at a certain percentage for a certain period of time, if we don't think there's any evidence of improvement, we will not put a routine future examination on it. In some cases, we do. And in that case, the veteran will be required to attend an examination down the road, 3-5 years. And at that time, we'll take another look at the disability and see how long it's been at that particular evaluation, if we think we should propose to reduce, if we think that it's episodic improvement, if it's what we call static, meaning it's been at that level for 5 years or more. In a lot of cases, to answer your question in a different way, a lot of times we don't know that there's been improvement. If we don't put a routine future examination on something, then we don't know that there's improvement, in which case the evaluation just continues to run. And we may never find out that there's been improvement in the disability. Sometimes they'll file a claim for something else. Like you mentioned, post-traumatic stress disorder. They may come in and file a claim for a left knee, and through our review of records, we'll see improvement at that time. And in which case, we may schedule an examination then as well, routine future examination then as well. That's a good question. Does that address it? Okay, thank you.
And that's what I was just about to say.
Go ahead, Nick.
So there's actually an entire process associated with reducing a rating, and before they ever reduce a rating, VA has to send out a letter to the veteran telling them, hey, we're proposing a reduction, submit anything that you have that would show us that your condition hasn't improved yet. In that case, the veteran's going to send in letters or doctor's notes, whatever they have, to show that it either has or hasn't gotten better. I guess if it has gotten better, they don't have it. After that, it's, 30 days is the requirement?
The initial is 60.
60. So within 60 days, then the VA can turn around and make a decision on that and reduce the rating. Now, that reduction in rating is still appealable, too. So say the veteran doesn't feel like it's gotten better. I've actually had a case just last week I was working on that the veteran had episodic improvement, and based on that CMP exam, when he went in and had a really good day, his rating was reduced. And so we've been appealing that, but you would file your NOD just like normal. And in that case, you're going to have evidence that the rating hasn't, or the condition hasn't improved. So again, you're going to be searching for that IME. You're going to get the buddy statements and everything else.
Would that same approach apply to TBI?
Yes, that same approach will apply to any service-connected disability and the evaluation associated with it. And I apologize if I made it seem as if the VA is just going to take that away. We won't. There's the whole process that Nick just described that we would go through. I saw another hand up here. Did that?
Has there ever been any consideration of legislation being in place to prevent the re-victimization of these trauma victims who then have to go back and relive this whole experience and the same process?
She asked if there's been any proposed legislation or anything in the pipeline to try and keep from re-victimizing specifically PTSD veterans, MST veterans, when they go in for that CMP process. Not that I've heard of. Have you heard of anything along those lines?
No, I have not. And I know the VBA, so our side of things, Veterans Benefits Administration, as well as the VHA, the Veterans Healthcare Administration, I know is growing and taking big steps to try and address the military sexual trauma from both sides, the healthcare side of things and the Veterans Benefits Administration side of things, to keep the re-victimization from happening. And I know they are working toward making that process smoother. As far as specific legislation and specifics of what is happening, I don't know.
And I think
Brief follow-up to that. So when you're looking at these, these files, as VBA, do you have access to see their psychologists and psychotherapists notes on your own, or do they have to resubmit that?
Her question is, do we as VA adjudicators have access to the mental health notes? Are they VA Medical Center mental health notes? Yes, we have access to the VA Medical Center records, so we can see everything and where the treatment has been and what treatment's been received. Lots of hands. Who was next?
About records from like Fort Hood or other bases in the country, medical records, do you have access to those?
the medical record should be associated with the file during the development process, and they should theoretically all be in the claims file. If there's something missing specifically, the veteran can usually point the VA to it or to private records even, and they'll request those to associate it with the file.
If you're talking about, you mentioned Fort Hood specifically, if you're speaking about service treatment records, so records from when you were on active duty or on reserve or guard duty, yes, those will be in the file. If you are a retiree being treated at an Army base or at a DOD facility, those we will not automatically get because you're being treated as a veteran. So if you're at Fort Hood as a dependent or as a retiree, you'll need to tell us that those records are there and we will go and obtain them. I think there was a question up
I was
front.
going to say, I think we can probably take one more, but we're getting kicked out.
Question, I think. I'm just curious about like the process at your desk. Like when you receive a notice of disagreement, how long does it take for you to go through it? If I were to submit additional information, how does that affect how much time you spend making your statement?
Her question's about timelines and the DRO review on a notice of disagreement or once an appeal has been filed. And the answer is it depends on the case. I can tell you a hearing loss ringing in the ears case is going to take me a lot less time than a traumatic brain injury PTSD case. Sometimes it depends on how much evidence is submitted. Unfortunately, it's hard to give an average because every case is so very individual. You mentioned submitting additional evidence. I can assure you that anything that is submitted is looked at. We look at everything. I open every single document that has been submitted and I look through everything that's come in. I can tell you the VA we're required to do a certain amount of work every day. And the VA, this is how the VA counts it. I could do one case a day if it has 50 issues. A 50-issue case may count for 3 days worth of work for the Department of Veterans Affairs. Or I could do 6 one-issue cases in a day, or I could do one-issue case in 4 days. No, I don't. Somebody above my pay grade may have that number, but I don't.
I actually think the numbers are out there, but I couldn't tell you where exactly to find them. Yeah. I think she was looking once it gets on the desk, weren't you?
Yeah, I'm just kind of looking like for individual DROs. I understand where you're waiting your information, but I know there's also there like hearing your PTSD.
Yeah.
And that makes sense.
It's very hard to say. It is. But I can tell you that any DRO, including myself, that does this job, just like any other VA employee, we're required to produce a standard. And if we don't, we're out the door. So the government production rate is set, and even that's a little bit questionable. But keep in mind too, this is all changing in 15 months, 18 months, when the appeals process changes. But that's for a different date.
That's next year's symposium, the new appeals process. So grab one more cookie And we have one more speaker. We're not talking about ratings anymore. We're going to talk about discharge upgrades. And that will conclude the symposium after Danica.
Thank you.